Many people believe that non-attorneys get the same deal as attorneys do in traffic court, and that's simply not the case. First, a prosecutor knows if the offer isn't good, he's going to have to go up against an experienced lawyer at trial. Second, prosecutors see us again and again. We have relationships with many prosecutors, and that helps us get better deals. Third, if the offer isn't good, we know what to counter-offer, and we know a good deal when we see it. And finally, we know which infractions will affect your auto insurance and which ones will not. Therefore, if the initial offer isn't acceptable, we may be able to get your ticket reduced to something different, which will have the same effect, in that it will not affect your auto insurance. If an officer makes a minor mistake on your ticket, chances are it will not be dismissed. As long as the officer can prove the essential elements of the case, you will be convicted at trial. The only mistake that can make a difference is, let's say they write the wrong date and/or time, and you can prove that you were somewhere else on that date and time. In all other cases, if you're in a court that permits plea bargaining, a plea bargain or settlement is a better option, because if you take the ticket to trial and your only argument is that the officer made a mistake on the ticket, you will probably be convicted and you'll get the points and the fine. People are usually surprised when I tell them that there's no rule, policy, or law that requires a case to be dismissed if the officer doesn't show up. First of all, in courts that accept plea bargains, the officer is never scheduled to come for the pretrial conference because the court is trying to encourage people to settle. Even if your case is put down for trial, the officer may call in with an excuse. Say he had to respond to a road emergency or he wasn't working that day. A judge can adjourn or postpone a trial as many times as he or she wants until they're satisfied that the police officer is simply not coming to court. So while it may be true that an officer may not come to court and that will lead a court to dismiss for lack of prosecution, it's very rare, and even when it happens, it's only after a number of court dates. Justice always prevails. I wish that were true. The fact is that over 90% of traffic trials go in favor of the prosecution. And it's understandable because most issues boil down to credibility. The officer is usually viewed by the judge as being unbiased and just doing his job. You have a great degree of bias because if you lose the case, then you're going to get points and fines. So for that reason, if you're in a court which accepts plea bargains or settlements, and that option is made available to you, that's probably the way to go. I can't tell you how many times I've been in court where I've heard a prosecutor encourage a defendant to accept a deal because, quote, the driver's safety course knocks 4 points off your driving record. That's not true. If you read the fine print, it explains that the driver's safety course will reduce up to 4 points, and it defines reduce as reduce the point accumulation total. So for example, it takes 11 points before you get suspended. If you have a 4-point speed and you take the driver's safety course, it will reduce your total down to 0, and it will take 11 more points in order for you to get suspended. However, the infraction will still stay on your driving record for 39 months. So for insurance purposes, the insurance company is going to see it there, and you can still get increased even though you've taken the driver's safety course. The only way to get those points reduced is to fight that ticket in court.